My brother was already raising a glass when his attorney called to tell him he had lost everything. I watched it happen from the far end of the hallway, still holding my copy of the documents. My name printed at the bottom of a page that no longer meant what he believed it meant. He had his back to me, one hand pressed flat against the wall for support, and I could hear the attorney's voice clearly enough through the phone to catch the specific words that made his shoulders drop. Recorded declaration, witnessed testimony, irrevocable clause. His wife Diane was standing beside him. She had been laughing 30 seconds earlier. She was not laughing now. I should explain how I got to that hallway, because the moment only makes sense if you understand the 14 months that came before it. My mother was diagnosed with early-onset Parkinson's in October of the year I turned 28. The neurologist delivered the news in a small beige office in Raleigh with a laminated brain diagram on the wall and an expression of practiced neutrality that I would come to recognize over the following year as the face people make when they have learned to detach from outcomes. My mother sat very still throughout the appointment. On the drive home, she asked me to stop at the pharmacy on Glenwood Avenue, and then she was quiet the rest of the way, looking out the window at the city with the particular expression of someone recalibrating their understanding of time. I am a forensic accountant. I work for a mid-sized firm in Durham that contracts primarily with insurance carriers and civil litigation teams. My job is to find the places where numbers have been altered, where documents have been adjusted, where the paper trail tells a different story than the one being presented. It is not dramatic work. It involves a lot of spreadsheets and cross-referencing and sitting very still in front of two monitors for long stretches of time. It also means that I have spent years training myself to notice when something is slightly off. The document dated on a day that doesn't align with the timeline, the signature that sits at a marginally different angle from everything else on the page, the metadata that contradicts the printed date in the corner. I notice these things the way other people notice a crooked picture frame. Automatically. Without effort. My brother did not account for this. That was his first and most consequential mistake. He is 7 years older than me, and for most of my childhood I understood him the way you understand weather. As a force that moved through the house without much reference to the people in it. He had a talent for appearing at moments of celebration and disappearing during anything that required sustained effort. When our father left, my brother was 17 and gone 3 months later, citing a scholarship to a school in Tennessee that my mother could never quite remember the name of when relatives asked. He came back periodically over the years, each return marked by the particular energy of a person who wants to be seen as having done well. He married Diane when I was 22, and I attended the wedding in Charlotte and sat at the outer edge of the family table and spoke to him for approximately 11 minutes across the entire weekend. When my mother's diagnosis came, I called him that same evening. He listened for a while and then said that he would look into some options and get back to me. He did not get back to me. I stopped waiting after the second week. What followed was mine to carry alone, and I carried it. I reorganized my schedule around her medication windows. I converted the guest room of her house on Millbrook Road into a proper care space with grab bars and a raised bed and the specific mattress overlay her physical therapist recommended. I drove her to appointments on Tuesday mornings and Thursday afternoons. I learned to recognize the particular sound of her voice when she was masking symptoms. Slightly too measured, slightly too deliberate. And I learned not to call it out directly because she had spent her entire life being competent, and being treated as less than competent was its own kind of loss. I filed the insurance appeals when her carrier denied coverage for the occupational therapy sessions. I won 3 of the 5. The other 2 I let go because some battles consume more than they return. My brother came twice in 14 months. The first visit lasted an afternoon. He stood in the kitchen with his hands in his pockets and made comments about the medical equipment with the expression of a man who found disorder personally offensive. Diane did not come inside. She waited in the car the entire time with the engine running. The second visit was 2 weeks before the end. He stayed for 1 night and left before breakfast, citing a work obligation that he described with vague importance and no specifics. My mother died on a Wednesday morning in December, which was also her birthday, which felt like the kind of detail that would matter more later than it did in the moment. I was there. My brother was not. The will reading was scheduled for the second week of January, handled by my mother's longtime estate attorney whose office was on Six Forks Road in a building that smelled of carpet cleaner and old wood. I arrived early. My brother and Diane arrived together, 7 minutes late, dressed in the kind of careful neutral tones that suggest someone has given thought to appearing appropriately somber without fully committing to grief. He squeezed my shoulder when he came in, which was the first physical contact we'd had in years, and it felt like a performance for the room. The attorney, whose name was Mr. Bellamy, had handled my mother's estate documents for over a decade. He was a careful, methodical man who kept his files in labeled binders and spoke in complete sentences and never appeared to be in a hurry. He opened the session by explaining that my mother had updated her estate documents approximately 11 months prior, which I knew because I had driven her to that appointment. She had made a modest but deliberate update: the house on Millbrook Road to be divided equally between her 2 children, her personal accounts and investment portfolio to be split the same way, with a separate bequest of her jewelry and personal letters, to me specifically. My brother listened to this with a stillness that I registered without understanding. Then he reached into the interior pocket of his jacket and placed a document on the table. It was, he said, a subsequent amendment, signed and notarized 6 weeks after the appointment with Mr. Bellamy. In it, my mother had allegedly revised her distribution to leave the house and the investment portfolio entirely to my brother, citing his role as her firstborn and what the document described as substantial financial contributions to her care during her illness. The room did not go quiet dramatically the way rooms do in films. Mr. Bellamy picked up the document and read it. Diane examined her hands. I looked at my brother. He looked at the wall slightly to the left of my face, which is what people do when they are trying to appear neutral and succeeding only at appearing practiced. Mr. Bellamy asked where the notarization had been performed. My brother named a UPS store on Capitol Boulevard and provided the notary seal number from the bottom of the page. I did not say anything in that room. I wrote the notary seal number in the Notes app on my phone, and I wrote the date printed on the document, and I wrote the name of the notary stamp, and then I asked Mr. Bellamy for a brief recess to process the information, which he granted because he was a decent man who understood that grief and paperwork are a difficult combination. In the hallway I called a colleague named Jerome, who does title work and has more experience than anyone I know with notary authentication. I read him the seal number. He was quiet for a moment, and then he told me to photograph the document front and back and send it to him before I left the building. That evening, sitting at my mother's kitchen table with a cup of tea I did not drink, I went through what Jerome had sent me. The notary seal number on my brother's document was registered to a notary in Mecklenburg County whose commission had expired 4 months before the date on the amendment. The notary had not renewed, which meant the stamp on that document was either borrowed, purchased, or fabricated. Any of these would make the document legally invalid. Beyond the seal problem, Jerome had flagged something else. The font used in the body of the amendment was a version of a common legal template that had not been available in that particular format before my mother's health had deteriorated, to the point where extended writing was already difficult for her. The physical plausibility of her having independently located, filled out, and arranged the notarization of that document in that specific window was, to use Jerome's careful language, extremely limited. I sat with that for a while. I thought about the drive home from the neurologist's office. I thought about the Tuesday mornings and Thursday afternoons. I thought about the insurance appeals. I thought about the birthday that was also a Wednesday in December. Then I made a decision that I want to describe accurately, because it would be easy to frame it as something it was not. I was not angry in a way that required an outlet. I was not interested in spectacle or confrontation for its own sake. What I felt was closer to the stillness that comes when a set of numbers finally resolves into a clear and unambiguous picture. There was a problem with a document. I knew how to handle problems with documents. I called my brother and told him I needed more time to review the amendment before I could agree to proceed. I said this with a slight catch in my voice that I had not specifically planned but did not correct. He said he understood that there was no rush, that family came first, that he only wanted to honor what their mother had wanted. He said, their mother instead of mom, which was a tell I filed away carefully. I spent the following 4 days doing what I do professionally. I requested the original estate documents from Mr. Bellamy's office. I cross-referenced my mother's medical records against the timeline on the amendment. I contacted the UPS store directly and asked whether their notary had any record of the appointment. The store manager confirmed that their notary had been on medical leave during the week the document was dated and had notarized anything during that period. I obtained a certified copy of the notary's commission record from the county clerk's office, which confirmed the expiration date Jerome had identified. On the 5th day, I called my brother and told him I was ready to meet and discuss next steps. He suggested his house in Cary. I suggested, with the mild reasonableness of someone making a logistical rather than strategic choice, that we meet at Mr. Bellamy's office instead, since the documents were there and it would be easier. He agreed without hesitation. What I did not tell him was that I had already had a separate conversation with Mr. Bellamy 3 days earlier. I had walked him through the notary evidence and the timeline discrepancy and the medical record documentation. Mr. Bellamy had listened without interrupting and then sat very still for a long moment and then told me that he had, in fact, thought something about the amendment seemed unusual when he read it, but that it was not his place to make accusations without evidence. He thanked me for bringing the evidence. He also told me something I had not known. He told me that approximately 13 months ago, during one of my mother's appointments, she had asked him about the possibility of including a provision in her trust that would address any future challenges to its validity. Mr. Bellamy had recommended a no-contest clause and a video declaration. My mother speaking directly to a camera in his office, articulating her wishes and her reasoning in her own words, dated and witnessed by 2 members of his staff. She had done this. The recording existed. She had spoken for 22 minutes, clearly and specifically about the house on Millbrook Road and the investment accounts and what she wanted her estate to mean. She had mentioned, by name, the value she placed on the daily care she received in her final months. She had not mentioned my brother. I want to be precise here about what happened in Mr. Bellamy's conference room when my brother arrived and sat down and looked at the documents arranged on the table. There was a moment, perhaps 4 or 5 seconds long, when he believed he was attending a negotiation. His expression had the specific quality of a person who is prepared for resistance and is ready to absorb it as part of a process that will ultimately go their way. Diane sat beside him with a legal pad and a pen, which told me she had expected to take notes. Mr. Bellamy began by asking my brother if he wished to confirm his position that the amendment he had submitted represented a valid and accurately executed change to his mother's estate documents. My brother said yes. He said this clearly and on the record. Mr. Bellamy then explained, with his usual careful precision, the notary commission expiration, the UPS store records, the medical leave documentation, and the timeline inconsistency with the document's font. He placed each piece of evidence on the table in sequence. He did this without dramatics, the way you present findings to a regulatory body, item by item, each one building on the last. My brother's first response was that there must be an error. His second response was that his mother had told him verbally about her wishes and that the document was simply putting those wishes into writing. His third response came after Mr. Bellamy played the video recording on his office laptop, and that response was silence. In the recording, my mother spoke about the house the way she spoke about everything she cared about, specifically and without performance. She described the garden she had planted along the back fence. She talked about the kitchen renovation she had done in the early 90s with money she saved herself. She said she wanted the house to go to the person who had shown up. She did not say this as an accusation. She said it the way someone states a principle they have held long enough that it no longer requires justification. My brother sat through the full 22 minutes. When it ended, he looked at Diane, and then he looked at me for the first time since he had entered the room, and I saw in his face the particular expression of a person who has just understood that the room they are standing in is not the one they thought it was. He left the conference room without speaking. Diane gathered her legal pad, on which she had not written anything, and followed him. In the hallway, I heard him call someone, his own attorney, based on the tone of the conversation, and I heard the attorney's voice through the phone, not loudly but clearly enough, explaining that the submission of a fraudulent notarized document in estate proceedings was not a civil matter. and that depending on how the other party chose to proceed, it could become something significantly more serious. I did not follow them into the hallway. I sat with Mr. Bellamy for another few minutes and we discussed the paperwork required to formally invalidate the amendment and confirm the original distribution. He offered me a glass of water, which I accepted, and we talked briefly about the garden my mother had mentioned in the recording because it turned out he had seen photographs of it once, years ago, when she had come in around the time the roses were blooming. The formal ruling on the estate came down 6 weeks later. The amendment was invalidated. The original distribution stood. My brother's attorney, who had apparently reviewed the fabricated document before advising his client to submit it, received a formal complaint referral to the state bar. I did not initiate that referral. Mr. Bellamy did on his own because he said it was the appropriate thing to do given the circumstances. I want to tell you what I actually felt during this period because the story is easy to misread as something triumphant, and what I felt was more complicated than triumph. I felt the specific tiredness that comes after a long period of sustained alertness. I felt something adjacent to grief that was not exactly grief for my brother, because grieving requires a prior condition of closeness that we had never really had. What I grieved, more precisely, was the version of a family that had never materialized. The brother who might have shown up on a Thursday afternoon, who might have sat in the kitchen with a cup of coffee and helped me figure out which insurance appeals were worth filing. That person had never existed. The loss was of an absence, which is a strange thing to mourn. I also felt something I was not expecting, which was a kind of gratitude toward my mother that arrived quietly and stayed. She had made the recording before her symptoms progressed significantly. She had done it calmly and specifically and without being asked. She had thought ahead in a way that protected both herself and me, and she had trusted Mr. Bellamy to hold that protection in place. She had been thinking about this longer than I knew, and she had handled it in the manner she handled most things, methodically, privately, and with considerably more foresight than the people around her gave her credit for. I used a portion of the estate to pay off the remaining balance on a student loan that had been following me for 6 years. I had the garden on Millbrook Road properly maintained through the spring because the roses she had planted along the back fence were still alive, and I was not prepared to let them stop being alive. I kept the house for several months before deciding what to do with it, and during that time I went there sometimes on Sunday mornings and sat in the kitchen with a particular quality of light that came through the east window between 8 and 10, which she had told me once was her favorite time of day in that room. I deleted my brother's contact information from my phone. I did this not with anger, but with the specific deliberateness of clearing a file you no longer need. I have not heard from him since the estate was settled. I have not looked for a way to. I had 2 sessions with a therapist in the months after, which I mention because I think people underestimate how much of this kind of experience lives in the body rather than the mind. The first session I spent mostly describing logistics. The second session I spent mostly sitting with the question of what it means to be the person who stayed, whether that is a virtue or a pattern, whether caregiving freely becomes something else when the people around you begin to treat it as a fixed feature of the landscape rather than a choice being made over and over again. My therapist said something I wrote down and kept, that the act of noticing you are being taken for granted is itself the beginning of a different relationship with your own limits. I found that useful. The rest I am still working through. What I return to most often is a small and specific memory. The afternoon I drove my mother home from the neurologist's office after the pharmacy stop. She was quiet for most of the ride. Then, somewhere on Glenwood near the intersection with Millbrook, she reached over and put her hand briefly on mine where it rested on the gear shift. She did not say anything. She just left her hand there for a moment and then moved it back to her lap and looked out the window again. I have thought about that moment many times in the months since. I think she was telling me something she did not have words for yet. Or perhaps something she believed I already knew. I think she was right that I already knew it. I think she was also making a decision, quietly and without announcement, about who she trusted to hold what she had spent her life building. I did not let her down. I want to say that clearly, not because it requires an audience, but because it is simply true. In all the ways that mattered. Across 14 months of Tuesday mornings and Thursday afternoons and insurance appeals and medication schedules and the long careful work of showing up without being asked, I did not let her down. There is a version of this story where I miss the notary expiration date, where I am too exhausted or too deep in grief to cross-reference the seal number, where I assume the paperwork is legitimate because believing otherwise requires an energy I am not sure I have left. I think about that version sometimes, not with fear exactly but with attention, because that version was closer than it might appear. And I think there is something worth keeping visible in how close it was. So let me ask you something. And I mean it the way my mother meant her hand on mine. Not as a flourish, but as something real. If the person you had cared for most carefully left behind something they wanted to protect, and someone else decided that your exhaustion was their opportunity, how long would it take you to find the number that didn't match? And what would you be willing to do once you found it?